and welcome to another in our continuing video series of interesting talks with interesting people on a wide variety of subjects relating to the law. I'm your host, Rick Newman, Executive Director at the American Museum of Tort Law. Welcome. Our guest today is Joyce Vance, Professor of Law at the University of Alabama School of Law. She is primarily an attorney with a background in criminal law. She was the U.S. attorney. She's now a professor, and she wrote an interesting article in the Washington Post on March 12th titled, "Civil Suits May Pry Out the Information We Need to Hold Donald Trump Accountable. The former president faces at least 10 lawsuits and procedural rules he can't dodge." Anyone who's paid any attention knows that Donald Trump has been involved in litigation his entire life. He has brought and defended thousands of lawsuits. But Professor Vance makes an interesting argument about how civil litigation, as opposed to criminal litigation, may offer certain advantages in not only peering into Donald Trump's background and liability, but how all of us can benefit from discovery afforded in civil litigation. So it's my great pleasure to welcome Professor Joyce Vance. Welcome.
Thank you for having me.
So let's just start conceptually with the framework of the difference between criminal law and civil law as far as the whole process works. Can you explain it?
Sure. The lens that I have often looked through this situation at is a criminal law lens. And of course, one of the things that we hope to achieve through our justice system is accountability. That seems to have been fairly elusive, as you point out, in the case of the former president. But most people have focused on accountability in the context of the criminal justice system, with this real panoply of civil lawsuits that have been brought against the former president and his corporations. It occurred to me as I was looking at many of them that the discovery process might offer the first hint of accountability. You know, I think to people who aren't involved in the legal system, it sometimes moves at an inexplicably glacial pace. To those of us who are practitioners, justice can seem very slow. But long before one gets to the point where a decision is made by a judge or a jury on issues, on the civil side of the house, there's the discovery process that takes place, whether that's depositions or answering interrogatories. And this isn't something that one can dodge by saying that they don't wish to participate. The civil discovery process is obligatory, or at least lawyers on the side seeking discovery can make it as obligatory as possible. That's in sharp contrast to criminal process, where discovery is very one-sided. Most of the burden falls on the prosecution to disclose evidence that they will use at trial, as well as exculpatory evidence. And courts are far less likely to impose discovery burdens on defendants in those cases. So it's a very sharp contrast, along with all of those differences in the system that, of course, we're aware of. Things like in criminal cases, the government bears the burden of proof beyond a reasonable doubt. But in civil cases, it's a lower burden. It's the preponderance of the evidence. So even once we're past the discovery stage, when we're looking at decision-making or dispositive motions, burdens take place at a lower level and cases are more likely to move forward as a result of that.
Yeah, it's interesting. A criminal case is always the government, some branch of the government, the federal government, the state government, the local government, against the accused. And a civil case is lawsuits between people or between corporations and people in some way. And as you just pointed out, go on. I didn't mean to.
I was going to say, my husband is a civil lawyer. Now he's a civil judge. And the way we used to explain it to our kids was, at the end of mommy's cases, somebody might go to prison. At the end of daddy's cases, somebody's going to have to pay out money. And that's really the sharpest contrast between the two. On the criminal side, it's really litigation on behalf of the people, on behalf of our communities. Civil side is more about disputes between individuals.
And you were talking about the burden of proof. Can you just explain the difference between beyond a reasonable doubt and preponderance of the evidence?
And it stems from what we were just talking about. In criminal cases, we use the highest burden of proof known to our legal system because there is the risk that we will take away someone's liberty at the end of the case. And so prosecutors must prove their case. They must prove the existence of every element of a crime beyond a reasonable doubt. That doesn't mean beyond all possible doubt, all conceivable doubt, any speculation. It means beyond a reasonable doubt, the standard that you and I might use in making the most important decisions in our own personal lives. We as prosecutors are charged with convincing juries beyond a reasonable doubt that the crime was committed. So that's one branch, but this burden of proof is lower in civil cases. When we talk about preponderance of the evidence, we simply mean that it's more likely than not that it happened the way one of the parties is alleging. Obviously easier to prove in a court setting.
And then let's talk about the whole notion in civil litigation of discovery. What it sounds like to me is basically both sides have to put their cards on the table even before they go to court. Is that a oversimplified but fair statement?
But it's a really good oversimplification. I mean, discovery serves a lot of purposes, but one is for the parties to see if they can settle out of court before they bring into play court resources and go to trial. And so by getting everyone's cards out on the table, litigants are able to assess whether they think they're likely to win or lose and whether settlement is a better prospect than trial.
And it requires both parties to submit to a deposition, which is what?
So a deposition is an opportunity to question, often, as you point out, the party to a lawsuit under oath before you get to trial. There's not really something comparable on the criminal side. Prosecutors can use grand jury proceedings where witnesses make statements under oath, but typically there's a carve out for the defendant. That's not the case in these civil proceedings where a defendant can be deposed in the discovery process and has to answer questions that are posed to him or her.
So would this mean that if these lawsuits against former President Donald Trump proceed, he may have to give depositions in these cases?
I think that's entirely possible.
Won't he just be able to say, I'm taking the fifth, I'm not going to answer?
So that's a really interesting question. You know, up until this point, the trajectory in litigation involving the former president, whether it was the Mueller investigation or whether it was unrelated civil proceedings, was to assert some sort of an executive privilege that prevented him from having to submit to legal process like normal citizens do. He had some success with that while he was in office. That's now removed. He can't exert executive privilege. And so the fallback could be the Fifth Amendment. You don't have to testify in a way that would incriminate yourself, certainly in criminal proceedings, and to some extent in civil proceedings. But that really only works when there are criminal proceedings against you that you have concern about. And of course, Donald Trump has repeatedly said that only the guilty assert the Fifth Amendment. So it'd be an awfully bad look for him to now come in one of these civil cases and say, you can't depose me because it might make me look guilty in a criminal case.
Interesting. And then what about other forms of discovery before trial? They have interrogatories and requests for production of documents. Can you explain just sort of conceptually what those are?
Sure. So in civil discovery, broad categories of documents are often requested. The parties will sometimes spend a lot of time narrowing those requests to what's reasonable, because as you can imagine, and particularly discovery has expanded in the computer era with so much more information stored and accessible. So sometimes parties will agree upon key search terms or restrictive time limitations, other ways of keeping production of documents manageable. But at bottom, the parties are entitled to discovery on relevant matters. And so in some of these civil cases, that could be very limited. A woman named E. Jean Carroll has sued Donald for defamation. At issue is whether or not he raped her decades ago. she will likely seek genetic sampling from him to see whether a dress that she has kept since the events that she alleged occurred matches his genetic coding. So that could, if there's a DNA match, that could become a very interesting case. But others of these cases, Trump's niece, Mary Trump, has sued him and other family members for fraud over the management of assets that they held as fiduciaries for her. That will be what lawyers call a paper case, right? Lots of documentation at issue. And so combing through that discovery, in my experience at the start of my career as a civil litigator for 6 years, whereas many young associates in big law firms do, I spent a lot of time reviewing discovery. You sometimes come up with smoking guns that are absolutely amazing evidence.
So using Trump again as our example, can he just say, I don't want to do this anymore? I'm not going to give depositions. I'm not going to produce documents. I just leave me out? Or could he be forced into doing this?
He can't do that. There might be some limitations, some reasonable restrictions on what he has to do, but ultimately a judge can and should compel him to participate in the discovery process, just like anybody else who's part of a lawsuit. And his options at that point are to comply, to fail to comply and be compelled, perhaps to be held in contempt of court even, or to settle the lawsuit to terminate the discovery proceedings.
And he can also, and I think he has also taken interlocutory appeals where he says, this decision, this particular order is so important, I'm going to appeal to a higher court just on this issue before we finish the case.
But you only get to take an interlocutory appeal from a final appealable order of the lower court. Discovery orders in civil cases typically are not final orders that can be appealed. So I don't think that's going to be very availing for him.
And as a result, we're back to the thesis of your article. These civil lawsuits, and there's 10 or so of them now, may actually be the pry bar into his background that he has been trying to conceal for years.
During the Mueller investigation, Trump always said that his personal finances were a red line that prosecutors couldn't look at. Of course, that's absolute bunk, right? Prosecutors are in fact obligated to evaluate evidence of crime wherever they find it. Mueller apparently took a very restrictive view of his jurisdiction, and that's fair. But to the extent that evidence was developed of other crimes, it would certainly end up in the hands of other prosecutive units, which I think is why we see Cy Vance, the Manhattan DA, with the investigation he has, which makes the point that this discovery that happens in one case, whether it's criminal or civil, can often be transferred into the hands of other prosecutors. It's a complex and intertwined process.
So this has been very interesting. It's informative, not only as it pertains to Donald Trump, but it's a good lens so that people can understand that civil litigation, by forcing the parties to sort of put their cards on the table, does foster settlement. It fosters fairness during the trial, and it eliminates a lot of unpleasant surprises at the last minute.
It really does. Litigation by surprise is something that I can make a good argument shouldn't exist in our system of justice, right? We want to have incentives for parties to resolve their differences as quickly, speedily, easily as possible so that people can get on with their lives. And one of the important trends we've seen in our criminal justice system in the years that I've practiced, and also in the civil system, to be frank, is a trend towards increasing discovery. And so I think justice is served when on both sides of the house, there's just open discovery. Let folks see what's there, understand what the evidence is, and let our justice system serve its primary purpose, which is the resolution of disputes so we can all get on with our lives.
Well, this has been very interesting, very informative. I think we'll all be watching the news to see what happens with these many lawsuits against former President Trump. But I think it's also instructive for anyone who gets involved in civil or criminal litigation to understand how the process works. This has been really very helpful. Thank you very much, Professor Joyce Vance, University of Alabama School of Law.
Thanks so much for having me. This has been a lot of fun.